Hello, you're listening to Ipsa Dixit, a podcast on legal scholarship. I'm your host, Brian L. Fry, Spears Gilbert Associate Professor of Law at the University of Kentucky College of Law. And my guest today is Guy Hamilton Smith, Sex Offense Litigation and Policy Fellow at the Mitchell-Hamlin School of Law. We're going to be discussing his powerful recent paper, The Digital Wilderness, A Decade of Exile and the False Hopes of Lester Packingham. Welcome, Guy.
Hi, Brian. Thanks for having me.
Yeah, my pleasure. It's so great to have you on the show. I'm really looking forward to talking with you about your fantastic paper. It's been really great to see it come to fruition, and I think it's really having an important impact on the conversation around this really important issue. So I was wondering if you could just provide a little bit of context for the listeners.
Sure.
Who is Lester Packingham anyway, and what role does he play in your paper?
Well, Lester Packingham is a North Carolina man who had committed a sex offense. And as is, sort of fairly common, I'm sure most listeners are probably sort of have at least some degree of familiarity with sex offender registries and stuff like that. North Carolina had passed a law that basically said, well, if you've been convicted of any kind of a sexual offense, then you can't use any kind of social media. And this law, I think, was passed in, 2008, 9, sometime around then. And so several years went by, and, Lester Packingham, he had a Facebook account, and he posted on his Facebook page sort of giving thanks that a traffic ticket was dismissed, and he was, praise be to God, this, that, and the other thing. But so unfortunately for Mr. Packingham, authorities were sort of monitoring, his Facebook page, and they were monitoring Facebook, and they came across his profile, and they realized, oh, well, this is actually a crime for him to have a Facebook page. And so he was convicted of, he was arrested and then convicted of this crime of having a Facebook page. And that ended up working all the way up through the state sort of appellate courts, all the way up to the United States Supreme Court on this question of, can states sort of ban people who have been convicted of any kind of a sexual offense from using social media, under the First Amendment. And the decision was North Carolina, or I always get it sort of flipped back and forth, Packingham versus North Carolina or North Carolina versus Packingham, thanks to dyslexia. But the decision was basically, no, you can't do that. And it was written by Justice Kennedy, who is actually very eloquent in his sort of... he basically came out and said that social media sort of represents the modern public square. And he was very sort of forceful in saying that, look, these people who've been convicted of, some sort of a crime, however many, years ago, perhaps they, more than most people, can benefit from being sort of exposed to the sort of marketplace of ideas. And so the Supreme Court essentially, and it was a unanimous decision, though the sort of more conservative wing of the Supreme Court wrote a concurrence. But essentially it said these laws are not, they don't pass constitutional muster under the First Amendment.
Interesting. So after the Supreme Court decision in Packingham, does that mean that states can no longer regulate the use of various forms of social media and the internet by people who are listed on sex offender registries?
Well, it means there was some dicta in the Packingham decision where they sort of left open the question as to what states can do. And also, it's also important to sort of note that the Packingham decision just applied to people who were not on sort of supervision, be it like probation or parole, which there's a long sort of line of cases talking about, in the Fourth Amendment search and seizure context, that people on probation or parole sort of have a reduced, Fourth Amendment interest. So Packingham just applied to sort of people who are no longer under sort of on paper is sort of the parlance. They're no longer under criminal justice supervision. But the other major aspect to these laws that Packingham did not address are sort of requirements that sort of generally that people who are on, these registries, these sort of public conviction registries, provide to the state a list of, sort of quote unquote online identifiers. And what that means or could mean sort of vary from state to state. But one of the things I sort of explore in the paper is that even though Packingham didn't really address these laws, they can, in some instances, represent sort of a de facto ban, even if it's not like an outright, you can't use social media, which obviously wouldn't pass muster under Packingham. States are, still have laws that say, well, you have to provide a list of, every identifier, and if you don't do that within these sort of hyper-technical time frames and procedural requirements, will convict you of a new felony. And there are some states, like Louisiana is one, where like Louisiana doesn't have a social media ban, but what they do say is if you're on one of these registries, then you have to sort of put in your profile that you are that you're a sex offender and that you have been convicted of this offense and what the offense was, your home address. You have to put all that in your social media profile. So I think it sort of blinks reality to suggest that, that's not a ban on, using social media, because no one is going to be able to say, well, I'm going to get on Facebook and I'm going to put all that in my profile. People are just going to say, well, I'm not using social media, which is exactly what Packingham says is not permissible. And so, but that's not what the law doesn't say it's a ban, but that's the obvious sort of impact. And so that's one of the things I explore in the paper.
Okay, how common are these kinds of state law restrictions on the use of social media by people who are on sex offender registries? And do they tend to be consistent from state to state, or is there a lot of variation?
There is a lot of sort of state to state variation. Some states don't have any, you can have states that don't have any law or any restriction on that. And then you have states, sort of like Louisiana or North Carolina or Kentucky prior to Packingham, had, similar legislation. But yeah, it can very much sort of vary from state to state as far as sort of what's required. Because really, again, all Packingham did was it just said you can't have a law that says you can't criminalize the use of social media. But, it didn't address the ways that states are sort of continuing to criminalize that use, sort of through the back door. And that's not to suggest that, someone's use of criminal or social media to commit a crime, such as like solicitation of minors, shouldn't be, punished. Of course it should be. But there are already laws that do that. And one of the points in some of the lawsuits that kind of filtered up prior to Packingham, that I think it was Judge Kopf in the Seventh Circuit or in the Nebraska, I think, who basically said, it's sort of, why are you even doing this? Like, if you wanted to have the deterrent impact, just make it a higher grade of offense if you have a prior conviction, and then you get the added deterrent impact without offending First Amendment principles. So it sounds like states are kind of de facto banning, or at least attempting to ban, people in some states, maybe not more so than others, from social media using a regulatory method rather than an outright prohibition on the use of social media. What kinds of requirements are states using to do that, and what kinds of consequences are associated with failing to follow the various state regulations? Well, what's pretty common is, sort of the general requirement is you have to report your internet identifiers to authorities.
Guy, what is an internet identifier?
Well, Brian, that's a really good question, and it's a question that courts have had difficulty resolving, because these laws are generally drafted by people who are not technocrats, like they're not employees of Google. They tend to be not very technologically adept, and so the legislation detailing what is the requirement of an online identifier, or what an online identifier is. It's been struck down in various jurisdictions on being sort of void, offending the vagueness principle, void for vagueness, and has, in other jurisdictions sort of led to people being convicted of, these are felony offenses if you sort of fail to, abide by these requirements. Like there's one case that I'm sort of write about in the paper, that of Mark Minnis in Illinois, where the Illinois statute is actually very sort of complex. It requires, if you communicate online, you have to report, I think it's, any URL, used in any web address used in that communication. So in Mark Minnis's case, he was I believe a teenager who it was sort of, if my memory serves me right, it was sort of almost a Romeo and Juliet type case, but where he was then over the age of consent, and his girlfriend was below the age of consent, and the relationship became criminal, and so he ended up on the registry, and so he updated his Facebook profile picture, and he did not report that to state police, and so they discovered that, and they arrested him and charged him with a felony offense for failing to register. So it as far as what these laws require, it can be extremely granular, and which in my argument, I guess you'd say, is that deters anyone from speaking at all. If there is this very real threat of criminal prosecution for doing, and again, for engaging in speech which is totally harmless and innocuous, then having the very real prospect of a serious criminal prosecution sort of undermines what Packingham seeks to kind of amplify, which is freedom of speech.
Mm-hmm. Well, I assume that states make it very clear to people what they're expected to do in order to comply with the law, right?
Again, sometimes yes, sometimes no. And when you're dealing with a statute that, my opinion of the statute at issue in Illinois in Mark Minnis's case is very complicated and very granular. So, even if the state, even if the state clearly communicates what's expected, but if what's expected is you have these, 100 simple rules that you have to abide by at all times, and if you make even the slightest miscalculation or mistake on any of them, then you're guilty of a new felony offense. The argument is that, well, even if you've communicated that to the person, that's not no even reasonably intelligent person can comply with that. And of course, states don't always clearly communicate that. These laws are constantly changing. They're being, amended. New restrictions are, sort of more generally outside the context of just online communication. New restrictions are added every year, and people aren't necessarily informed what they are. But they're all oftentimes strict liability type offenses. So there's no sort of requirement that the person had to know that this was a crime. It's just sort of strict liability. And again, failing to adhere to them means, generally a new felony prosecution, and a trip to, sort of prison. And that's and that's assuming that the person who is expected to comply with the law is isn't struggling with mental illness, substance abuse issues, and that's also just incredibly common.
So when you say it's a felony offense, maybe you could give a little bit more color just so
Sure.
people better understand what that means. What are the consequences then for someone like Mark Minnis, for example, who updated his Facebook profile picture without notifying the police? What happened to him?
Well, I tried to find out sort of what the outcome of that case was. And I think it's sort of still in the I think it's sort of still in the works. Last time I checked, but a felony offense is, it's more serious, generally speaking, than it's just a grade of offense. You have misdemeanor sort of offenses, and then there are felony offenses, which are generally regarded as more serious, but in pretty much...
That's so strange, because it doesn't seem like a very serious offense.
I mean, it doesn't to me either. These are essentially regulatory rules that, there was no one can really, I think, credibly claim that anyone was harmed by Mark Minnis's failure to inform the state police that he updated his Facebook profile picture. But, nevertheless, it's, under state law, it's a felony offense. And, in many jurisdictions, these kinds of offenses for failing to comply with these rules or failing to, they're actually the most common reason why people on registries are returned to prison. It's not because they've committed a new sort of crime like burglary, or it's not because they've committed another sexual offense. It's because they have sort of failed to dot the I on page 46 of Form T, which is, it's become a real... It begins to, I think, implicate due process concerns.
Yeah, I have to wonder. I mean, it's a little bit of a tangent, but when people talk about, for example, recidivism in the case of sex offenses, I wonder if laws like this play any role in the statistics that people tend to cite.
Well, the statistics are kind of, it is interesting because when you talk about recidivism and reoffense rates, you have to be very sort of attentive to what, you're sort of talking about and how you're defining recidivism. Because if you define reoffense rates in terms of like another sex offense, which is, I think, what most people think about when they hear sex offender, the data and the studies and even data from the Department of Justice all show that actually those instances are very, very, very rare. But instances of like technical violations for if you're on supervision, like probation or parole, or a new felony offense in the form of failing to register, those are actually very common. But that's not what people think of when they think of a new, they think of, oh, well, if, a sex offender commits another offense, it's got to be another sex offense. But that's actually very rare. That is, I think, data. The Department of Justice study of people who were released from prison in 1994 is, I think, one of the most widely cited statistics on it, and it's something like a 5% rearrest rate for a new sex offense. So, like 95% of people who were convicted of a sex offense and released from prison in this study, like, were not rearrested for another sex crime. So the vast majority weren't.
Wow. So I can't help but wonder, at least based on your research and what you've seen, how commonly are these kinds of regulatory restrictions enforced? Are they discretionary on the part of the district attorneys and so on? And sort of what's the practical on the ground effect on people's lives? I
mean, I think what it really comes down to is this is one of the sort of the vectors by which mass incarceration is sort of evolving, is sort of changing. Because each of these sort of laws, if you view them in isolation, they don't sound that bad. Like, they don't sound, it doesn't sound like, oh, well, that doesn't really burden someone's liberty. But, you have to keep in mind that that's just like one of a set of, 100 different sort of laws that a person has to abide by. And when you sort of, to use a legal term, the totality of the circumstances, when you look at the totality of the circumstances, it essentially becomes a new kind of prison cell where you're essentially walking through a minefield. And so you have to be extremely kind of careful lest you unknowingly or unwittingly commit a new crime. And, these are, I think in the sense that all crimes are discretionary, that district attorneys don't necessarily have to bring these cases. But, I don't think there's certainly any political motivation to, not press these sorts of cases. Like, it's good, for, just the optics of it are, I think, politically good to say, well, we got a sex offender off the street, when never mind that person's offense, sort of predicate offense, the reason why they're on the registry may have been 20 years ago, and they may have gotten married and had a family, and their crime was they failed to, they went back to school and forgot that they needed to report that to state police, and then that's a felony offense. But the headline is just, sex offender arrested for new felony. And so people read that and think, well, we got a sicko off the streets. But the reality is, oftentimes a lot different than that.
Yeah. In your paper, if I recall correctly, you observe that in some cases anyway, it can be really hard to know even exactly what these laws require you to do. Am I remembering that correctly?
Mm-hmm. Yeah. I think people generally want to comply with the law. No one wants to be arrested. No one wants to go back to prison. And sort of these laws, I think if for instance, Mark Menace had realized that he needed to tell state police that he updated his profile picture, my sense is he probably would have, because in order for state police to my understanding of his sort of the factual background of his case was that the reason why state police saw that he changed his profile picture was because he told them that he had this Facebook page, as he needed to do. He needed to tell them under the law. So it's baffling to think that, he's trying to nefariously use this Facebook page that he told state police about, and that's why we need to charge him with this felony offense for failing to let them know, by the way, I changed my profile picture. So yeah, I think it's oftentimes very difficult for people to adequately understand what's required of them, or even if that's clearly communicated to them, that assumes that, one, they can remember everything that they need to comply with at all times, and two, that they're not struggling with some sort of mental issue, that they are, or substance abuse issue. Because in my paper, I think it's in the introduction, I kind of break out this colloquy that's given to this juvenile in Ohio about all the things that he's going to be required to do for the rest of his life, and it fills about half the page, all of the different requirements. So I think I understand people. I absolutely believe people need to be held accountable for their actions. People need to be held accountable for harm that they cause to others. But at a certain point, I think it also needs to be recognized that at some point that punishment should also end. And these sort of systems have begun to morph into this kind of never-ending Kafkaesque sort of punishment that doesn't actually have any valuable benefit for public safety.
So it seems a little strange. For a 9-0 Supreme Court decision saying that people have a fundamental First Amendment right to engage in speech on the internet. On your description, it sounds almost like it's been overruled sub rosa by the states and the lower courts, to the extent that, if you can't really vindicate that right safely without putting yourself at risk of going back to prison on another felony charge, is that really a right at all?
That's sort of the open question. States in these laws weren't passed in sort of response to Packingham. They were sort of on the books for the most part, sort of all along. But that's the exact point that I hopefully make in the paper, is that if you have a right, but you can't actually, if you have a voice, but you don't have a way to make it heard, then do you really have a voice? Because then the other aspect to the paper is that, of course, as I'm sure your listeners are probably familiar, the First Amendment just constrains the government. It constrains governmental action. It doesn't have anything to say about what private parties can and can't do. So there's this kind of constitutional limbo where you have a highly sort of unpopular and despised group of individuals who the Supreme Court has said you have this right. You have the First Amendment right to be in the public square. The government can't stop you from being there. But the public square is now run by private entities, like Facebook, Twitter, MySpace, all these sort of social media platforms, and they're not the government.
No longer Google Plus, huh?
No longer Google Plus. Yeah, I think Google Plus, I guess, went the way of the dodo bird. But these platforms are free to adopt their own policies as to who they admit and who they prohibit. And Facebook, and also Instagram, they have a policy that anyone who's been convicted of any kind of a sexual offense, it actually doesn't matter if they're on a registry or not, if they've just been convicted of any kind of a sexual offense, whatever it is, they're prohibited from the platform. So, you have this pretty large population of people. It's, we're talking, roughly 1 million people who are, despite Packingham, banned from the, probably the most popular public squares out there.
So, Guy, what do you think the next steps are going to be? Do you think there's appetite at the Supreme Court for revisiting this issue? Have you noticed any momentum in circuit courts to wrestle with this kind of paradox or problem in sort of the theoretical right that people have and the practical limitations on their ability to exercise it?
I'm not sure. I know that the Minnis case, which perhaps I'm just reading too much into the timing of it, but they sort of petitioned the Supreme Court for a review, and the Supreme Court denied review on the question of whether or not this sort of statute about you have to report every URL you use was constitutional. They denied the certiorari petition, I think, a week after they decided Packingham. So I don't know if there's any appetite there to really explore these issues, and the litigation in the lower courts and also lower federal courts and also state courts about these issues about internet identifiers is very kind of hit or miss. Some courts have been very sort of generous in terms of their reading of the statute, and whereas others have been more willing to take a skeptical view. And as far as the sort of the private end of things, like that, I think is very much an untested Wild West almost. That you have this group of people where how can you force a private entity to admit these people that they don't want to admit, even despite Packingham saying that this is the modern public square. I think this is kind of I don't know if it's one aspect of this new sort of era that we're entering, where politics and the modern public square are on these platforms. And what is that? What are the implications of that for the freedom of speech, for the First Amendment, and for how we sort of, conduct our democracy. That's one question that has to be answered that I'm not sure there are really very many easy answers to at this point.
Wow. Well, Guy, thanks. This has been really fascinating. I really appreciate you coming on the show. I just wonder if you have any final thoughts or observations you'd like to leave listeners with as a way of wrapping up our discussion of your paper.
Yeah, I think that, I understand that again, like I said earlier, I think it's important that people are held accountable for crimes that they commit. I think that's an indispensable aspect of justice. But, at some point that punishment also ends. And when the punishment, ends after it's a prison term or whatever it is, then I think the issue is how do we reintegrate these people into society, and how do we help them to become law-abiding and productive members of their communities? So they, that's, I think, ideally what we want. But, there are all these sort of laws that have grown up around when it comes to sex offenses and sex offense registries that essentially work to, prohibit that same reintegration that people are supposed to be sort of engaging in. And so I guess I want to challenge people to think a little bit more critically about these sort of laws and whether they're helpful, or whether they're ultimately, harmful. Not only to like people who I understand most people aren't going to be moved about sort of the rights of people who've committed, crimes or specifically sex offenses. But, it's really it has broader implications than just an unpopular group of individuals, because that's sort of where, I forget the exact quote, but, that's where a lot of our, the conflicts about our most sort of cherished rights are forged, is in these conflicts of really unpopular people.
All right. Well, thanks so much, Guy. It's been a really pleasure having you on the program today.
Yeah, thanks for having me, Brian.
Okay, I hope we can talk again soon.
Thanks.